and he knew that she was in charge, and he told her that people already had went to the FBI against her, saying that she brought them to Mr. York to be molested, and that there was no way for her to convince the FBI, to prove to the FBI that that it never happened, and that she needed to go along with the story so that she wouldn't be brought down with Mr. York. She continued to tell him that he never molested me. I never saw anyone being molested. I don't want to do that. But he insisted on her, going along with the story. They went back and forth about it, and he just told her that they would talk about it later.
On our way back to Florida, the trip back from Florida, we was driving in Jacob's car again. It was myself, Karima, Nicole, Farah, Noah Rashid, and some other driver, I don't remember his name. And Jacob brought up the conversation again, how he thinks that we should really go to the government with a story about his father. Anything that we didn't like in the community, we should go, because his father needed to be in jail. His father did not do good things. He was not happy with his father, and he really felt that a case should be brought up against his father. He really felt that his father should be put away for life, that he did not deserve to live.
Adrian, you mentioned that the post-trial counsel, Jonathan Marks, was ineffective for withdrawing the appellate's motion for a new trial and motion for judgment of acquittal without properly informing and receiving the express permission of the appellate.
Yeah. What's important at any critical stage of a trial, particularly when there are critical motions, such as what I filed. See, these are motions I filed right after trial. I had a time limit to file the motions. I didn't have the benefit of a transcript, but by being trial counsel, I knew the errors generally that I wanted to handle. So I immediately filed a motion for new trial and motion for judgment of acquittal. Motion for new trial is based on trial errors that I felt the judge had made, and basically giving Dr. York an unfair trial. The motion for judgment of acquittal is basically that the evidence was insufficient. Plus, I knew it was more detailed, and I can't remember everything right now. It was more detailed points than that that went from the improper grand jury to several different points. I made those from memory. Then I reserved the right to modify that before the transcript was prepared. All right. Now, I was forced off the case, basically, after I filed initial motions and Jonathan Marks was hired. And what he did is withdrew the motions, just blindly withdrew the motions. And at that point, since that's so critical to Dr. York's defense, he should have expressly told the court that I'm familiar with the motions, I'm consenting to withdraw those motions, because at any critical point, and this is general premise of criminal law, state, federal, whatever, is at critical points such as entering a plea or when you have a substantial right that could be withdrawn, you need to expressly do that before the court.
Right.
Acknowledge that you know what it is, that you are given the authority to withdraw, and you agree with that. That was not done. Just the word of Jonathan Marks, or an implicit word, because I don't even think it was explicitly withdrawn, was done. But the point is, Dr. York was not informed of what was going on, and he did not expressly say, I don't want those motions anymore. You follow me? This was done and masked in the midst of the Abigail Washington recantment. And the focus, while Abigail Washington's recantment was important, these other motions were just as important. Because you're talking about basic trial issues that were problematic, pre-trial issues that were problematic. So there should have been a full understanding, especially of the rights that he would be giving up. The bottom line is, I was challenging every count that alleged Mann Act violations, and so I had to specify. It was quite a long indictment.
Gotcha.
Basically, in this particular count, Ed Garland, doing his questioning of Jaylene Ward, who was the lead investigator on this case, he did establish, and this was a positive thing he did actually, he did establish that the government had no witnesses and no evidence to support the claim of interstate, that the intent of the interstate travel was for sex with minors. That destroys the entire federal part of the case. You can be kept with a state potential case, but if there's no evidence to establish that the purpose of the travels were sex with minors, then you don't have federal jurisdiction.
All right, now, in connection with the travel for the purpose of having sex with a minor, do you have a witness who says that the purpose in the travel was to have the children have sex?
The witnesses that says that?
Yes.
No.
You have no witnesses that says that?
Not that says that. No.
All right. That's all I'm going to have for this witness at this time, Your Honor.
And what happened, my first witness during the presentation of my case was the lead investigator for the FBI, which is Jaylene Ward. Well, what happened when the judge asked me did I want to present a case, I said, yes, we have a case. Who should call you first witness? I said, Jaylene Ward. She was sitting at the prosecution table. The judge stopped the case, didn't initially allow me to call her, said the government stood up and said he can't call her. I said, why can't I call her? She's the lead investigator. That's my first witness. Well, she's not on subpoena. I said, I'll subpoena her. The judge gave the government a 4-hour recess to try to find case law to support the reason why I could not call the lead investigator. And we took a recess. The judge granted a recess just to give them time, middle of trial. Let the jury go out and try to prevent me from calling her.
But I think too, we're talking about the same entities. I think originally the government requested they only needed 10 minutes, I believe.
Right. What happened? The government said they needed 10 minutes to pull a case that established that I can't call the lead investigator in the case. All right. So we gave them 10 minutes. They couldn't find it. Then the judge gave them however long they needed. Judge didn't say 4 hours. He just said, get back with me when you find your case law. Ended up, we went to lunch. Came back. Still in recess. It ended up being a total of 4 hours, and in the end, they didn't find any case law. And they quoted the case now, but it was an administrative case.
Exactly.
They had no presidential,
under the CFR,
value. Right.
Code of Federal Regulations. See, also too, what this amounted to, all right, is that, and what you're going to see when you look at the trial transcripts, that Judge C.S. Raw in this case had given the government a large latitude in terms of prosecuting Dr. York, but gave his defense little or no latitude to defend him. All right, and that's the travesty of
case in point.
All right.
During the film of the trial, I was down there by myself, me and Dr. York. I requested that I have an assistant in the courtroom. I said, well, Your Honor, I would like an assistant in the courtroom to help me with files and things like that. And the judge said, I said, Your Honor, the government has like 3 attorneys, 2, 3 assistants, and da-da-da. I just like an assistant in the courtroom. The judge said, no, you can't have an assistant. But Ed Garland can have someone from his firm come in. And I pretty much, I mean, I can't exactly remember the response, but I pretty much had established I was the lead counsel. Ed Garland, I think, only had, one guy, man, a word that he wasn't there. So government even prevented me from having an assistant in the courtroom just to help with basic things like getting paperwork and things. So I had to pretty much conduct